You just got named Successor Trustee, and somewhere between the funeral and the paperwork, it hit you. What if I mess this up? If that's where you are right now, you're not alone. Almost every first-time trustee feels that way. But here's what most people assume, and it's wrong. They think that because there's a trust, all they have to do is follow the paperwork. But it doesn't exactly work that way. The trust doesn't make the decisions. You do. Every action, every dollar, every conversation, that's on you. And because you're the one making the decisions, the law doesn't just expect you to do your best. It imposes specific legal duties on how you make them. That's because a trustee is what's called a fiduciary. That's just a legal way of saying that the law requires you to put the beneficiary's interests ahead of your own. In fact, trustees are held to one of the highest legal standards that exists. And if you violate those duties, even accidentally, you can be held personally liable. I'm Darlynn Morgan, and for nearly 30 years, I've guided successor trustees through trust and estate administrations. And I've seen the same mistakes happen time and again. The good news is they're almost always preventable if you understand your legal duties. So let's talk about the 5 core legal duties that every successor trustee needs to understand. Each one comes from either the trust document itself or your state's trust laws. Not a gut feeling, not what seems fair. Actual legal standards that you'll be measured against. And one of these 5 duties gets trustees sued more than any other. I'll show you which one it is, and more importantly, how to avoid making the same mistake. So duty number 1 is the duty of loyalty. Let's start with this duty because it causes the most damage and because it's the one that people break even without realizing it. Your duty of loyalty means that every decision you make has to be made in the best interest of the beneficiaries, not in your own. So here's a scenario that comes up all the time. Mom and dad pass away. They leave the house in trust to their 4 kids equally. And the oldest one, who happens to be the trustee, says, I want to buy the house and take it as part of my share. Sounds harmless enough, right? But it's not, because the trustee is now on both sides of the deal, deciding what the house is worth and deciding whether to sell it to himself. That's exactly the kind of self-dealing that the law exists to prevent. So what do you do if you're actually in this position and you genuinely want to buy the family home? Well, there are legal solutions for this. And one is called a distribution or settlement agreement, where all the beneficiaries sign off. And as an individual beneficiary, you buy out your siblings' shares at an agreed upon fair market value and terms that benefit all the other beneficiaries. This way, everything is clear and documented and agreed upon in writing. So you're always asking, am I making this decision because it's best for the beneficiaries or because it's easier or better for me? If the answer isn't 100% clear, then stop before you move forward. Now, loyalty is about who you serve, but there's a second duty about what you owe them just by them asking. And that's duty number 2, the duty to inform beneficiaries. Beneficiaries have a legal right to ask you what's going on with the trust, what property it holds, and how you're handling it. And when they ask, you have to answer. State statutes typically require you to give beneficiaries complete and accurate information within a reasonable time of their request. Not weeks of silence or I'll get to it eventually, but a real answer with documentation behind it. Here's where this goes wrong. A trustee gets busy, or they're grieving, or they don't have all the answers yet, so they stop returning calls. And in their mind, they're just trying to get organized. But from the beneficiary's side, silence looks like something else. Weeks turn into months. The beneficiary assumes the worst, and they call a lawyer. Now, this reasonable standard doesn't mean you owe someone a weekly report or you need to be constantly answering multiple detailed questions whenever a beneficiary is feeling anxious. But when a beneficiary has a reasonable request for information about the trust, you have a legal duty to provide it. And a little goes a long way. If you say, I'm still gathering assets, I'll update everyone when I know more, that can prevent months of conflict. This informing duty is about telling beneficiaries what's happening. But the next duty is about proving it. And that's duty number 3, the duty to account. In plain English, that means that you're required to keep a clear, accurate record of everything you do with trust assets and to put that record together in a formal accounting, usually once a year. Every dollar that comes in and every dollar that goes out, every distribution you make must be documented, organized, and ready to show. Most states require at least one formal accounting per year covering income, expenses, and distributions, whether or not the trust document even mentions it. The mistake I see here is that most individual trustees don't even know that this requirement exists. I've seen trustees wait until the end of the administration to organize everything. But by then, they're digging through bank statements, they're looking for receipts, and they're trying to remember why they wrote a check 18 months ago. Now, that's a stressful position to be in. So instead, keep records as you go, save receipts, track every transaction as it happens. Not at tax time, and not when a beneficiary asks, but as it happens. Make notes about important decisions while they're still fresh. If a beneficiary ever asks a question, or a judge does, you'll have the documentation to back up everything you did. Okay, so that covers loyalty, communication, and accounting. The last 2 duties are about how you actually run the trust day to day. Duty number 4 is the duty to administer prudently. The law can't write a rule for every single decision that a trustee might face. So instead, it holds you to a standard. What would a prudent person do, given the purpose of this trust and its terms? That's the test. Not perfection, prudence. Most state statutes use the language reasonable care and skill as the catch-all standard that covers everything the trust document and the more specific duties don't already spell out. Here's a case that shows exactly what happens when this duty gets ignored. A trustee inherited a rental property as part of the trust, and overwhelmed with everything else on his plate, he just let it sit. There was no tenant, no maintenance, no property management. 9 months later, the property had lost real value, and the beneficiaries were asking a fair question. Why did this asset just sit there doing nothing? Now, that's not a criminal act, but it is a failure to administer prudently. And it's the kind of thing that gets trustees personally liable for the loss in value. Prudent doesn't mean being an expert. And there are market swings that no one can predict. But it does mean being careful and reasonable given what a thoughtful person would have done with the same information. That's what the law expects from a trustee. And now, the 5th duty. This is one that sounds obvious, but it's surprisingly easy to overlook. Duty 5 is the duty to follow the trust terms. I've seen trustees make decisions based on what they think is fair, what the family wants, or even what they believe the person who created the trust would have wanted. But none of those are what control. The trust document does. In fact, this is one of the biggest mistakes I see individual trustees make. They try to fix what they think mom or dad would have wanted, or they decide to change the distribution because all the siblings agree that it seems more fair. But that's not your job. Your job isn't to rewrite the trust, it's to carry out the trust. Now, I did mention earlier, there are legal solutions if it is truly the case that everybody agrees that a different arrangement would be better. There can be court-approved modifications or beneficiary agreements. But absent a formal written agreement or court approval, you must always follow the trust exactly as written. That's what you were appointed to do. So those are the 5 core duties that every successor trustee needs to understand. Keep those top of mind and you'll avoid most common mistakes. But just knowing your duties is only half the battle. The real question is, what do I do first? That's why I created my first 30 days checklist for new successor trustees. It walks you through the essential first steps so you can stay organized and avoid costly mistakes and move forward with confidence. So click the link in the description to download the checklist, and I'll see you in the next video.